Global happenings today. We communicate. We analyze global news.
Hello beautiful people, welcome back to our channel. While all are seated waiting for the arrival of mazi Nnamdi Kanu for this very big case, don't forget that some few days back, on Saturday precisely, Barrister Opara did mention the fact that DSS did not allow him entry to see mazi Nnamdi Kanu over the fact that mazi Nnamdi Kanu demanded some document to aid him over this event, over this court hearing that's to take place in a few minutes from now. But something happened some few hours ago that connected mazi Nnamdi Kanu's younger brother that is sparking reaction. We're going to give full details on that as we speak. mazi Nnamdi Kanu's brother is in court today, but the question is, what happened? Let's dive into the news proper. But before we do that, kindly subscribe to our channel. Now, tension fled at the Supreme Court premises in Abuja some few hours ago as Prince Nnamdi Kanu, the younger brother to the detained leader of the indigenous people of Biafra IPOB, mazi Nnamdi Kanu, was reportedly blocked and held by operatives of the Department of State Services, DSS. According to eyewitness accounts, Prince Kanu had arrived at the Supreme Court earlier some few hours ago to process legal document related to mazi Nnamdi Kanu's case, which is scheduled for hearing as at today, 2025, November 4th. However, DSS personnel stationed at the court allegedly prevented him from entering the premises. In a statement attributed to his wife, one of the DSS officers allegedly threatened to jail Prince Kanu after he questioned why he was being denied entry. As of the time of filing this report, Prince Kanu was reportedly still being held within the court premises, sparking concern among family members, lawyers, and even supporters. The development comes on some few hours from the crucial court date for Nnamdi Kanu, whose prolonged detention and trial have continued to draw widespread national and international attention. Kanu is currently representing himself in court after discharging his legal team and challenging the legality of his trial following his controversial rendition from Kenya in 2021. Efforts to reach DSS officials for comment on the incident have so far been unsuccessful. Of course, we continue giving you and monitoring the situation and keep giving you updates as more information comes and becomes available. I'm going to allow you to watch a video of one of mazi Nnamdi Kanu's lawyers who is privy to quite a lot of things, have decided to open up that there are quite a lot of intricacies going on in this case that meets the eyes. Let's watch this video. We'll come back for more.
I hope someday, somewhere, a journalist will ask him that question. But I'll tell you what. When I see statements issuing from the villa, not in particular from Tinubu himself, from President Tinubu himself, but from his underlings, that this matter should be resolved by the courts, it gets me thinking, is someone somewhere contriving some predetermined result from the courts? What is informing this blind confidence about the matter of mazi Nnamdi Kanu should be resolved by the courts? It begins to sound to me like someone who stole your election, and before you open your mouth, INEC tells you go to court. Like a mantra. It's suspicious. Why wasn't Ibuho's case resolved in the courts? Why wasn't the chairman of Miet Allah's case resolved? Because it takes me back to 1963, when they were also saying the same thing about the case of Bafemi Awolowo and Anthony Inahoro, charged with treasonable felony. And they were facing a trial in which they had the option of taking summary trial or the other, but they pushed them into summary trial and convicted them with a bat of an eyelid. It was a political trial. They were also saying it should be resolved by the courts. So his conviction was contrived. We learned later from Justice Cho that his hands were tied. So we have that provision in Nigerian Constitution that the Attorney General can discontinue a criminal prosecution. Why is it difficult to apply that to an Igbo man when that very provision had been applied to non-Igbos in recent times, including by the... He's fully aware of what he's doing. That's all I can say. to that.
Why do you think the Southeast governors are not championing the cause of Nnamdi Kanu's release?
It's for them to answer, and it's quite shameful that that is the conclusion that has been drawn. Since last year, when they declared in July last year that they were going to interface with the president on the issue of mazi Nnamdi Kanu, nothing has been done. So they just have to explain to Ndibo why they have not taken any step. The Southeast governors empanel themselves or convene themselves one day and say, this weekend we are going to Villa to discuss with President Tinubu on the question of this issue of mazi Nnamdi Kanu. I think, Ndibo will be very proud of them. That hasn't happened, and there are no charges facing him. Listen, let me tell you a story. You're not lawyers, but you know that once a law is repealed, it's repealed. Can you believe that the Terrorism Prevention and Amendment Act 2013 was repealed in July 2022? Mazi Nnamdi Kanu is still being charged under that old law, which was replaced in July 2022 by Terrorism Prevention and Prohibition Act 2022. We're in 2025, and you're still trying him on an old law. Let's not talk about extraordinary rendition, because somebody might say, oh, the Supreme Court said, okay, he was rendition, but he's still subject to trial. But there are other issues dancing around that. What about the root fair hearing that was not given to him in Kenya? If Mazi Nnamdi Kanu was offered the due process of extradition in Kenya, he may not be here today, because there are a lot of defenses to extradition within the extradition laws of any nation, including Kenya. So there are just so many issues, and he was discharged in October 2023. Okay, now this case took like a year and a half to get reinstated, and while that was going on, in fact, even at the Court of Appeal, the law was repealed. So what is he facing before the Nigerian judiciary now? Charges based on old law. It's for the courts to decide. But these are one of the defenses in Chile in America. At some point, Gandhi, the father of non-violent resistance, did it in South Africa before he escaped to India. I think Mandela tried to defend himself too at some point. And in 1963, we go back to Awolowo again. Awolowo defended himself. He was assisted by some lawyers, including one from England, who was denied entry into Nigeria, but eventually he was granted entry. So Awolowo defended himself. So a lot of defendants, people who were subjected to criminal trial, have defended themselves in history. Nnamdi Kanu will not be the first. But that does not obviate the fact that it does not need the advice of experts. If he feels question amongst legal experts, is it right, under jurisprudence, to subject a man to trial on a law that has not become final? What criminalized the IPOB activity and put Mazi Nnamdi Kanu in detention is the notion, the court order, that IPOB is a terrorist group. The court order proscribing IPOB. That court order, a lot of Nigerians don't know, is still under appeal. Section 36 sub 12 of Nigerian Constitution says no Nigerian should be put on trial except on the basis of a written law. Let us assume that the proscription of IPOB has become a written law. It hasn't become a final written law. It's still lying before the Supreme Court. These are some of the issues that I believe the executive branch should have looked at and say to themselves, well, what's the hurry? Maybe we should let this man go, because even the proscription upon which we are prosecuting him is not even final. It's not yet final. So these are the issues, the legal issues dogging his proscription. And these things are very likely to also occur as legal arguments in court.